Good afternoon and welcome to this Bristows webinar on competition law in the pharmaceutical industry. To try and make it more interesting than your average webinar, we've even given it a snappy title, so it's called Finding the Bright Lines in a Grey Area. And all of you will know that the pharmaceutical sector has been one in which the competition authorities, both in Europe and in the member states, have taken a considerable degree of interest over the last 5 years or so. And that followed a long period of time when competition law really didn't appear to be that particularly interested in the pharmaceutical sector, other than in one or two very specific areas. I'm afraid that has all changed, and so this afternoon we're going to try and take you through a number of the key issues that have really been relevant over the last 5 years. And my task, at least to start with, is to give you a bit of an indication into what's new in broad terms, both in the context of the European Union and its enforcement body, the European Commission, DG Competition, and also in the member states who have been particularly active in this field. As far as the EU is concerned, I think the principal area of interest really over the last 5 years has been in relation to products which are coming to the end of their patent protection, and the extent to which agreements between originator pharmaceutical companies or agreements between originator companies and generics have the effect of slowing down, in the view of the European Commission, beyond which is acceptable, the entry of generic products onto the market. And loosely speaking, this can be called Payfordelay. On the slide, I've made reference to 3 decisions taken by the European Union, so DG Competition, 2 of which probably go together quite nicely. And that's the first one, which is the Lundbeck generics case in relation to citalopram, and the last one, the Servier case in relation to perindopril. And the reason I say those 2 go together quite nicely is because they are, in large part, to do with settlement agreements around patent litigation. In both cases, and there are some differences which I'll touch on, the principal objection of the European Commission was that the generic companies had agreed with the originator company that they should either withdraw from litigation entirely or at least pause litigation in return for what was seen as being a significant value transfer. Now, the distinction between Lundbeck and Servier is something that Sophie will talk about a little bit more later in the talk. I think it's worth saying that in Lundbeck, as I mentioned, this was just a pause in the litigation rather than a full and final settlement. And in Servier, by contrast with Lundbeck, the Commission was looking not just at agreements between Servier and generics under Article 101 of the treaty, it has also identified an infringement of Article 102 of the treaty, which for those of you who follow this area of the law will realise is the part of the treaty that deals with the abuse of a dominant position, so unilateral conduct. And it's alleged that some of the things that Servier was doing in relation to perindopril, of its own accord, by itself, not by entering into particular agreements with anyone, were abusive of a dominant position. And there are arguably 2 problems with that. First of all, the way in which the Commission identified abuse, and then perhaps more surprisingly, the way in which they identified the relevant market for perindopril and identified that Servier had a dominant position within it. Again, those are things that Sophie will speak about. Now, the odd one out on the slide is the J&J Novartis fentanyl co-promotion agreement. This was not really, strictly speaking, a pay-for-delay agreement in the sense that it was to do with patent settlements. It was, in fact, an arrangement between J&J and Novartis in which one party paid the other to assist in promoting a product on the market at a time when it was alleged they already had their own product ready to launch. So it's a slightly different type of infringement, but it is fair to say that the underlying problem identified by the authorities was the same. Now, of the 3 cases on the slide, 2 of them have been appealed by the parties. The Lundbeck generics case was appealed earliest because it was the first decision, and I understand that that is due to be dealt with or be heard in October this year. The Servier case was a bit later in time, and that has also been appealed, but we don't yet know when that will be heard by the Court of Justice. The J&J Novartis case, actually, there was no appeal, so that is now a final decision. So that's Europe. What about our member states? The member states that have been most active probably are the United Kingdom, France and Italy. And as we're here in the UK, I thought I'd start with what our domestic regulator has been doing. It's been doing quite a few things. The one that I put at the top of the slide I mentioned first because it is a case which is quite similar to a couple of the cases the Commission's been looking at. Essentially, it is again a pay-for-delay type case where it is alleged that GlaxoSmithKline has entered into various agreements with generic companies in relation to the supply of paroxetine. There has been a statement of objections. The first one was in 2013 and the second was in 2014. And the CMA alleges that GSK threatened generics with infringement actions and then entered into settlement agreements so that the generics stayed off the market and got some money for doing so. Now, interesting thing about this case is that actually it's a bit of ancient history. It goes back to 2001 and 2003. It's also interesting that there's been no decision despite the length of time since the first statement of objections. Like the Servier case, you'll note that it's not just to do with multilateral conduct. There is actually an Article 102 or a Chapter 2 allegation against GSK. And it may be that that aspect of the case is more difficult for the CMA to make stick than the more generic, sorry, pardon the pun, the more general licensing or settlement arrangements that would fall under Article 101. The Pfizer-Flynn case is a relatively recent case where the CMA has commenced an investigation into excessive pricing. This is a situation in which Pfizer sold a product to Flynn, which Flynn is now marketing. Pfizer is still continuing to supply the underlying product to Flynn, and after the sale took place there was a very significant rise in the price at which the product was supplied by Flynn to the NHS. And the allegation is that this amounts to excessive pricing because the price of the product now bears no realistic resemblance to its economic value. This is a very unusual excessive pricing case. It's usually difficult, particularly in the context of innovative products or where intellectual property plays a role, for the competition authorities to find a way of establishing that a price is truly excessive. Here, very unusually, they have a before and after scenario relating to the same product. So that may make it a little bit easier. The final thing that the CMA has done recently is they were investigating a case in the UK in relation to alleged abusive conduct in the offering of discounts and rebates for pharmaceutical products. As it happens, they decided not to pursue the case because they felt that it wasn't a very beneficial use of their limited resources. But when they closed the case, they actually gave some guidance on rebates and discounts for dominant companies. It's interesting that this guidance was given in the context of pharmaceuticals. It actually doesn't tell us very much that we didn't already know. Essentially, what the CMA says is that, by and large, rebates that have a loyalty-inducing effect are likely to infringe the competition rules. And that's very similar to what the European Commission and the European courts have held for some time, and most recently in the Intel case. But interesting that the domestic authority felt the need to give that additional guidance. Italy has been not just active but hyperactive in this field, and I've just mentioned on the slide, and I'm not going to go into detail, a couple of the cases that the Italian authorities have been investigating. The first one has been around for quite a while. That's the latanoprost case. Those of you who follow this sector may recall the original decision was taken by the Italian Competition Authority that Pfizer had abused a dominant position by a variety of mechanisms, the point of which were to maintain its position in relation to latanoprost. That decision was overturned on appeal, and I think most competition lawyers thought that that was the right thing to do, because it was far from clear that the conduct that the Italian Competition Authority had identified was really going beyond normal competition on the merits, in the sense that they were that Pfizer was actually doing everything it was entitled to do under intellectual property law, and there was no suggestion, really, a la AstraZeneca, that they had been telling fibs or misrepresenting things to the patent office. Nevertheless, on final appeal, the original finding was reinstated, and that was, I think, fairly disappointing. So Italy has taken a fairly aggressive stance on so-called use of the toolbox to delay generic entry by originator pharmaceutical companies. The Roche Novartis Genentech case is one that has now mushroomed, and as you'll see on the slide, it's not only Italy but also France, Spain, the Portuguese and the Belgians have taken some interest in this case. This is a case which related to off-label use of Avastin. Now, Avastin was registered and licensed for use in relation to breast cancer. It was also used or prescribed by doctors off-label for a condition known as wet AMD. Lucentis, which was a drug also approved and owned by Novartis, was actually licensed for use in wet AMD. And the allegation was that Roche and Novartis agreed with each other that they would try and engineer a situation whereby Avastin could not be used for wet AMD, so no registration for that would be sought. They were fined a very significant amount of money by the Italian Competition Authority, and as I said, a number of other competition authorities are now seeking information or considering bringing proceedings in relation to the same course of conduct elsewhere in Europe. Perhaps more worrying for the parties, the European Commission has also indicated it's gathering information on that course of conduct. Finally, I think France has a particular take on these issues, and one of the things that we've seen in France that we haven't seen so much of elsewhere is the allegation that a dominant company can be abusing a dominant position by denigrating the quality of a competitor product. And the first case in which this arose was the Sanofi-Aventis case in relation to Plavix, where it was alleged that Sanofi representatives had spoken to doctors, and rather than just eulogizing the qualities of their own product, they'd actually said negative things about the qualities and the development of the generic product. So, for example, as on the slide, they said that generics only had 3 of the 4 indications that the originator had on their label, and that it wasn't the same salt that was used in stabilizing the product. Now, it's not clear at all that the information given to doctors by the Sanofi-Aventis representatives was actually false at all. But the allegation is that this was intentionally an attempt by Sanofi to play on the aversion to risk that doctors do have by trying to encourage them to write non-substitutable on their prescriptions. And once they do that, of course, generic products can't be prescribed in relation to that prescription. So there was an infringement decision, there was a fine, and that was confirmed by the Paris Court of Appeal in December last year. A further case of a similar nature has been brought against Shearing Plough, again in France. We haven't seen a case like that elsewhere in Europe. In England, there's been some court action. Most interesting probably is in relation to our rejection by the English High Court of an application for an injunction by a company called Chemistry, which may be known to many of you listening to this webinar. Chemistry has had a number of run-ins with major pharmaceutical companies, and this one in particular, they'd asked for an injunction to order AbbVie to supply it with certain products, and the allegation was that AbbVie was dominant in a market in which its product Coletra was a prime party, and that it had an abusive policy of not supplying wholesalers. The High Court, supported by the Court of Appeal, found, first of all, that there were a number of therapeutically equivalent products to the AbbVie product, so therefore there was no evidence of dominance. And then in relation to abuse, the court was quite clear that Article 102 does not preclude even a dominant company from adopting a particular manner of distribution. There's no obligation to supply everyone. So in the UK at least, for the time being, pharmaceutical companies are justified in having a policy of not making sales intended for wholesale, although it may have to apply that policy consistently. One of the things you'll find in competition law more generally is that inconsistency of conduct is something that can draw the attention and criticism from the competition authorities unless you have a good reason for it. So that's broadly speaking what's been going on in the member states. I was going to talk about the surveyor market definition issue, but actually I think Sophie's better placed to talk about that. So I was going to move really from this general introduction to a bit of an overview of the Payfordelay cases first, looking at in a bit more detail at some of the implications that they have, not just in that specific circumstance, but also broader implications elsewhere.
Thanks, Pat. So, as Pat said, I'm going to try and first of all talk a bit about the Payfordelay cases, by which we mean the Lundbeck, Servier, J&J cases in particular, and to try and both dig into those a little bit, but then also to start drawing some more general conclusions from them, because I think we do feel that they do have quite significant they give quite significant insight into how the European Commission in particular is thinking about these issues now, which has a broader implication for the industry as a whole, I think, than just for these specific issues. And I think probably the other thing to say about them is that the length of the cases is such that there is, I think they span about 1,500 pages altogether, the three cases, and so there's a sort of wealth of material in there to draw upon. Now, obviously I'm not going to touch on all of it today, but we've pulled out the things that we think are the most interesting, I hope, for this audience. Now, competition lawyers like talking about things like a theory of harm, by which we mean what effect on competition, what's the damage to competition created by the particular conduct under investigation. And I think it's quite interesting to look back both first at what the theory of harm the Commission suspected might exist in this case in the pharmaceutical industry, and then to look at a bit at how the theory of harm plays out in the case law itself. So if we look back to the famous sector inquiry that was launched around 8 years or so ago now, what the Commission said it was looking for in particular was reasons why there were apparent delays to generic entry in some cases. So, in other words, when a drug comes off patent, why do we not see immediate generic entry in all cases? And the other thing that was up front and centre at the heart of the sector inquiry was to look at the decline in innovation that has been well publicised in the pharmaceutical sector, in particular the decline in the number of traditional compound molecule medicines. Now, the Commission says it is still looking at stifling of innovation. Perhaps it is. I think one might query whether it's always looking at innovation in the same way as the industry looks at it, but that's perhaps a bit of a sideshow for these purposes. What is really relevant is to look at how the theory of harm plays out in the case law. Now, if we look at, and I'm going to go into a little bit more detail about how the case law actually addresses the way, how it actually develops a legal test, but just touching for a moment on some of the ways in which the theory of harm is identified in the cases. What they look at in particular is where there are restrictions on generics, and by restrictions, those are limitations that wouldn't have been agreed to by the generic but for a value transfer. And we'll come on to what value transfer means. Is it just money? Is it something else? In a little bit. For present purposes, what's interesting to look at is the concept of restriction. And here we're not only talking about actual delays to generic entry, but also other forms of limitation on the generic's ability to enter the market. And what, in the Lundbeck case, so the first of these three so-called Payfordelay cases, there's a sort of refrain that's used over and over again by the Commission, which is this one in red on the slide: the means used matter. So, in other words, the fact that Lundbeck was engaged in litigation with the generic companies and that it might have succeeded ultimately in, for example, reaching a permanent injunction against the generic competitors, that's irrelevant. What is irrelevant is the fact that it was reserved, that a similar right was reserved through the contract between Lundbeck and the generic company rather than through a court judgment. And that's, I think, something that's very important to bear in mind, because it's very tempting, particularly for those of us who think about patents and think about competition quite a lot, to think, well, you know, in any given litigation, assuming you're not talking about a sham, then there would be some prospect, at least, that the patentee would win and would succeed in keeping the competitor or the generic entrant out of the market. But the fact that such an agreement is reached in the context of a bilateral private agreement, where there is also critically a payment from the patentee to the would-be entrant, changes that analysis, and we can't anymore just think about the fact that the patent might have given the right to exclude. One further related form of harm which is identified is actually one that's been around in the case law for quite a while, but has perhaps received less attention in the sort of 1990s and early parts of the 2000s, and that is the idea of contractual reservation of rights to maintain, on the slide it says to maintain invalid IP rights. So what we're talking about here is the idea that in a contract a patentee prohibits the other party from challenging the patent or indeed other forms of IP right. And that is regarded as having the capability of harming competition, in that it leaves a registered right sitting on the statute books or on the patent register, and that has the potential to prevent third parties from entering, and it also might make the ability of the other party to the agreement to enter in a cost-effective way more difficult. So that's all very interesting. I think it's fair to say that the real harm that is being thought about in these cases is really in relation to the money. Now, it's obviously the case that in this industry we have a situation where there's a very dramatic disparity between the amount that is paid for on patent drugs and those which are paid for many, if not all, drugs which have become generic. And it's, you know, as Pat mentioned, there's a case going on in the UK at the moment about excessive pricing. The price of drugs is of wider policy importance than just in competition law. So on the slide we've got a couple of graphs, and those are sort of designed to show in a very basic way what the harm is we're talking about. So on each of the graphs you have effectively on the horizontal axis time, and on the vertical axis cost to the health service. The blue line is, I've called it the originator, but what I really mean by that is the situation that existed when there was a potential competition problem going on. So that shows, for example, on the left-hand side, it shows the patentee making a certain amount of money in terms of revenue from the health service over a period of time, and then that drops off quite suddenly. You can see that generic entry on that left-hand side would be at around between the years 4 and 5 at the bottom. The red line, by contrast, is what the competition authorities believe should have happened. So if generic entry had happened when it ought to have done, then the prices would have slipped much more quickly, and they would probably end up in the same place. Well, they might end up in the same place on the left-hand universe, but in the interim period, there's a significant loss to the health services in particular, which is in the UK, or insurance companies and so on in other jurisdictions, which is represented by the space in between the two lines. Now, most of the Commission's cases have focused on that left-hand sort of scenario, Some of the other cases brought by the member states' authorities, such as the French authorities, have actually looked a bit more at the right-hand situation. So that is where you have generic entry at the, quotes, right time, unquotes, but it is what's sometimes referred to as softened compared to the truly competitive situation. So in that scenario, you have the patentee maintaining more sales than it would have done were it not for the unlawful conduct or the unlawful agreement. I've put on the bottom of the slide that because this is about money, unsurprisingly we're seeing actions being brought by health services to try and recover some lost cash. I've called them follow-on actions, but actually some of these actions were started in advance of a commission finding, perhaps doubting whether the commission would ever get to a finding, which at one point seemed perhaps unlikely. So, for example, the health services of England and Wales and also Scotland and Northern Ireland are currently claiming against Servier for loss resulting from what the commission has now found to be unlawful conduct. So, turning now to start thinking about what the legal test in Lundbeck and Servier and J&J is. First of all, the Commission established that in each case, so I'm going to talk about Lundbeck I think for the time being, because for these purposes there's not much difference. So that Lundbeck and the would-be generic entrants were potential competitors. In fact, one point of distinction here, I suppose, is the fact that in Lundbeck, a number of the generic companies were actually on the market when Lundbeck first sued them and then subsequently entered into settlement agreements. Whereas in Servier, none of the generic companies were already on the market. They had at most an MA ready to launch. In each case, the agreements were concluded following patent litigation. There's no suggestion in the cases that the patents were sham or that the litigation was in some way fabricated. The agreements restricted the generics from entering in various ways. They restricted them from challenging IP. There was a value transfer, and again I'm going to come on to talk about the range of what a value transfer might mean in a minute. It certainly includes cash payments. And that the key that makes the restrictions anti-competitive as opposed to potentially more neutral is that the value transfer induced the generics to accept those restrictions and to therefore to cease or to perhaps to limit also their independent efforts to enter the market broadly across the EU. And if you look at J&J, as Pat mentioned, in the Johnson & Johnson case, this was about a situation where Sandoz is understood to have been developing its own product to compete with J&J in the Netherlands, but at some point, instead of entering in with its own product, it entered into an agreement with J&J whereby it would help assist J&J to co-promote J&J's own product around the Netherlands. So it follows again that J&J and Sandoz were potential competitors. The agreement restricted Sandoz from entering with its own product. And I've put it as an effective restriction because what the agreement said was you will get paid for the co-promotion until you enter with your own product, or less than until you enter with your own product. And they were sort of monthly payments. And it has to be said that the level of the payment appears to have been quite high, and therefore the Commission concluded that the agreement strongly incentivised Sandoz not to enter with its own product. Now, the critical thing here, both of these sets of agreements, or in all cases, this conduct was held to be agreements which restricted competition by object, so the most serious form of competition restriction. But the critical thing, I think, for comparing these sets of cases is the one is the fact that on the right-hand side, for J&J, there was no patent protection. So this comes back to the point I sort of tried to introduce earlier, which is that as patent lawyers, as competition lawyers who are used to dealing with patents, we have a tendency to think, well, there's a patent sitting there, so that is effectively an obstacle to entry, particularly when in the pharma sector where a compound patent is often going to be an absolute obstacle to generic entry. But here what you have is two cases which have identical legal tests in terms of determining whether there is a restriction, and even a restriction by object. But on the one hand, you had valid patent protection, so those on the Lundbeck and the Servier cases. But for J&J, there was absolutely no patent protection held. And yet, in spite of that, the legal test in both sets of cases is the same. So, we promised some bright lines. We should probably caveat this section by saying they're not that easy to spot. Now, the case law does make some warm noises about the ability of patent holders to use their patents to litigate and to potentially exclude infringers. They are very positive about the rights of companies to settle litigation, even patent litigation, good heavens. And they say that the vast majority of patent settlement agreements don't raise antitrust concerns. There's no presumption that patent settlements, even between competitors, are antitrust infringements. Now, that's all very well, but when you're in the middle of a piece of patent litigation and you're thinking about settling it, it's less easy to craft a solution unless one party or the other actually wants to give up altogether. And it's perhaps worth going back to the Commission's sector inquiry report, because that does sort of set out how the sorts of agreements that have no problem and the sorts of agreements where there is a potential problem. So first, if you're going to settle litigation and you're not going to there's no limitation on generic entry, then unless there's something else dramatic going on, then you don't need to worry any further. In cases where there is a limitation on generic entry, and I would remind you that the case law is pretty broad in terms of what's regarded as a limitation. I mean, in theory at least, a prohibitional challenge is a limitation on generic entry. That's perhaps more debatable. But nevertheless, if there is some measure of limitation on generic entry, then you're then into the more potentially problematic territory. Now, if there's no value transfer, and I keep saying this, but I'm going to come on to that in a minute, then there's generally no problem. If there is a value transfer, that's where you need much greater scrutiny. One thing that the monitoring reports say, and which was also echoed in Lundbeck, is that early entry arrangements may not attract the highest degree of scrutiny. I'm not sure how helpful that is as a comment by the competition authorities. I think it's something that you're going to want to be pretty cautious about relying on. However, if you're looking at a period between the date of the agreement and patent expiry, there's a certain duration up to that point. If there's no restriction in the agreement other than the entry date, and the entry date is perhaps nearer to now than it is to the date of patent protection, then you may be starting to look at a situation that is less risky than one where there is a much more significant delay to entry. Now, one thing that emerges from some of the more general discussion at the beginning of the Lundbeck case in particular is the fact that there's perhaps some distinction to be made between the situation where where a patentee is litigating, say, process patents, compared to where it still enjoys compound patent protection. And you see in the quotation I've put up from Lundbeck that there is this idea that the period of compound patent protection, as legitimately extended by an SPC or a paediatric extension or whatever additional regulatory right, is the right amount of time that the legislator has decided that products can be protected for. It's the right amount of time to allow the originator to recoup their profits. I mean, this is obviously pretty questionable in a number of ways, because after all, the legislator, in its wisdom, has also allowed companies to seek patent protection over other inventions such as process patents or formulation patents or whatever form of patent protection that goes on beyond the expiry of the SPC. But nevertheless, I think the fact that the competition authorities do have this view perhaps means that when you're looking at agreements within the period of initial patent protection, then those are perhaps less likely to raise significant alarm bells, particularly if you're being cautious about what level of benefit a generic is getting when the settlement is concluded. I would say that it's only a crumb of comfort, really, because the Commission makes very clear in the case law that the ability of generic companies to litigate patents is part of the competitive process, and it picks up on something in AstraZeneca to justify that, which in AstraZeneca, so that's the Court of Justice, there was this idea that there was generic pressure on the branded medicine existing for several years prior to patent expiry. So on that approach, the idea is that even though a compound patent may still be in place, it's not impossible that potential competition may exist. And the same applies even more so when you've only got a process patent, and where at that point in time the European Commission would say, well, at that point the market is in principle open to competition. Now, what about the case that the agreement you're proposing has no effects? You can probably guess from what I've been saying about the approach taken to the existence of a patent that it's going to be pretty hard to show that there are no effects, because if you have an agreement which introduces a restriction on generic, if you assume away the patent protection, then that restriction is simply two allegedly competing companies agreeing that one of them will delay their entry to the market, which is, getting pretty close to classic cartel type behaviour. And that is particularly so if you're sitting in the so-called object box, so where you've got a restriction of competition by object, and the competition authority doesn't have to prove that there's reasonably likely effects. Now, I don't know how much detail you want to get into on the details of pure competition law cases, but there has been a bit of a bust-up over recent years in relation to how and when object restrictions can be identified. And the carte bancaire case was one where the court has perhaps tried to re-establish a bit more the idea that object restrictions are those which are the very most serious restrictions, which are easily recognisable, don't require 1,000 pages of explanation to justify, and are therefore perhaps a bit narrower in what they can catch than the Commission has been trying to push with its Lundbeck and Servier cases. If that new approach is broad enough to undermine the Commission's Lundbeck decision, that's going to be quite critical, because it will mean that if a patent settlement agreement, even with a payment, can't be an object restriction, then the Lundbeck case will be, Lundbeck and the generics will win that case, because the Commission only pushed that forward as an object case. In Servier, perhaps because of the concern about the carte bancaire case, that was decided both on the idea that there was an object restriction and also effects on competition. But it's nevertheless much more difficult to always prove effects, because once you're looking at effects, there is the question of what would have happened with the patent, and there is also the question of whether the generic company would actually have entered even in the absence of an agreement. And it's just worth looking at this fairly recent US case, in which it was held that there was, looking at the US test, a large and unjustified payment which was unreasonably anti-competitive. However, the court wasn't persuaded that there was sufficient evidence to find that the generic would actually have entered the market any earlier without the settlement. Now, I've promised several times that I'll come on to value transfers. What the value transfer does, as I've tried to explain before, in the European Commission's eyes and in the eyes of the Competition Authority, is that it persuades companies to accept restrictions that they would or might not have accepted were it not for the payment. And the idea is that it distorts the company's incentives. So instead of just proceeding on the basis of their of what they think the likely outcome of the litigation will be, so their perceived strength of their position in the litigation, they may say, well, okay, you're paying me enough that it makes it worth my while to abandon my chance of winning. Now, the difficulty with that as a test is that it's extremely difficult to rely on being able to prove that you accepted certain restrictions in an agreement, even though you had even though your perception was that you were going to that the litigation was going to come to a particular outcome. So the question really is it ever safe to rely on the likely outcome of the litigation in the absence of a payment? And I think the answer has to be probably no. There's some warm words spoken in the Lundbeck case. Not all settlements involving a payment necessarily infringe, and that a payment may be instrumental in finding an acceptable legitimate solution. But 70 paragraphs later, you see that the payment is a clear warning signal. Now, in Lundbeck, Lundbeck settled with a number of companies, many of which found their way into the decision. One which didn't was the Neolab company, the Neolab generic. Now, Lundbeck paid Neolab in order to, according to the agreement, to compensate it for the fact that its entry into the market had previously been delayed. In some ways, it seems quite strange that wasn't characterised as an infringement. But I think the key is in the point on red on the slide, which is that once the agreement was reached, Neolab was then immediately allowed to enter the market. So my feeling is that as soon as you've got a form of value transfer, then it's imprudent really to say, well, I thought I was going to lose the litigation anyway, so it was better to settle, unless you've got some very clear and cogent evidence, which of course isn't privileged, or in which you're prepared to waive the privilege. Then you're probably going to be on pretty thin ice trying to rely on that approach. Is a value transfer only an actual payment? I think it's becoming fairly clear that it's not. The patent monitoring reports, which have been launched every year in conjunction with the monitoring of patent settlement agreements initiated by the Commission after the sector inquiry, talk about a number of other potential types of value transfer. So, for example, if a patentee grants a would-be generic entrant the right to distribute their own product rather than launching with a generic product, grant of a license, sale of assets, and so on. It's worth looking at one of the agreements which was challenged in Servier, and from which, having been in the case, I'm sort of aware was an extremely controversial one, and yet has nevertheless found its way into the decision. And this, I don't think I'm giving anything away from the public version of the decision. This was the settlement agreement between Servier and Kirker. Kirker had challenged Servier's patent in the UK. It was already on the market, so it had a product ready to go. It was already on the market in Eastern Europe. In some of those countries, the patent in question that Servier was suing on in the UK hadn't yet been granted. It was still at the application stage. Servier and Kirker, there was also litigation going on with a couple of other companies. It's probably quite important to understand that, because when Servier and Kirker settled, there was no reason to think that those two pieces of litigation wouldn't continue and reach a judgment at the same time as the litigation between Servier and Kirker would have done. And indeed, one of those pieces of litigation did continue, and at which Servier's patent was revoked in the UK. So Servier and Kirker, in that context, entered into a patent settlement agreement. Kirker dropped its challenge to the patent in the UK and agreed not to enter in the UK, because obviously it was actually injunctive at that point, so there was no reason for it to want to enter. But it took a license from Servier in Eastern Europe at a sort of normal royalty rate. There was no promise by Servier not to license third parties in any country, and there was no payment, apart from the royalty payable, in fact, to Servier. However, because Kirker was only permitted to enter in a subset of the European Union countries, this is now considered by the European Commission to have created a de facto duopoly in those countries where Servier and Kirker are on the market, and also to have essentially reserved Servier's right to maintain its own position as a monopoly in the other countries where Kirker might otherwise have entered. Now, to my mind, I still find that quite an extraordinary decision, because what you have here is a company that had entered the market at risk, which is now licensed and which is providing competition to Servier in those markets. In the meantime, you have litigation continuing in the UK and reaching a conclusion. So it's hard to see what the harm to competition is, but I think, and I very much hope that this will be the sort of high watermark of how these cases are considered. But it is still a salutary reminder that you've got to think about value transfer in a pretty broad sense when you're looking purely at settlement agreements. And I've just put at the bottom that because this behaviour is being, in my view, perhaps wrongly likened to cartel type behaviour, there is the prospect now of kind of companies taking a more cartel-informed approach and perhaps using some of the tools that are available to cartellists to bring agreements of this kind to the attention of the competition authorities. I'm about to hand over to Pat because we're going to start moving out into what these cases mean for broader transactions, in particular in licensing. But just before I do so, I was going to just run through the idea of potential competition. So I've been glibly talking so far about the idea that the patentee and the generic are competitors. On a traditional view of the way potential competition is considered in competition cases, that's pretty questionable, because for one thing, there's a patent in play which might restrict the generic's ability to enter the market. For another thing, pharmaceutical molecules are often very difficult to manufacture, and often generics, in their race to get onto the market early, may perhaps encounter more manufacturing difficulties or more difficulties obtaining MAs than they'd expected. So I think it's true to say that there are a number of cases where generics have got further ahead with the patent litigation than they have really with their product development, which you can see can create an incentive for them to want to reach some other arrangement, particularly if they think other generic companies out there may have got a bit of a faster route to market. So here I've sort of listed out some of the areas where you might question whether a company is a potential competitor. Now, if a generic's already on the market at risk, I think it's fair to say that you would probably expect them to be viewed as a potential competitor. I mean, even that is slightly at odds with the approach in the merger context, where the Commission tends to look at whether a company has the ability to remain sustainably on the market. But nevertheless, it's perhaps not that surprising. Now, if they hold a granted MA and they're not yet on the market, again, it's not surprising. They're viewed as a potential competitor. The mere fact they're alleged to infringe patents, as we discussed, is irrelevant. But then you get into slightly more interesting territory. So what if the generic hasn't yet got an MA? Well, I suppose you might think they might be very close to obtaining one, and once they obtain one, they can enter pretty much straight away. So, okay, they could be a potential competitor then. If their product's not ready, to me, this is now starting to stretch the concept of potential competition, but again, it may depend on the stage the product development has reached. What happens if they're actually receiving significant concerns being raised by the regulatory authorities? Again, according to the Servier case in particular, they are still a potential competitor. Close to bankruptcy, still a potential competitor. All of the above, still a potential competitor. I mean, it sounds a bit farcical, but the approach that has been taken in the cases has been that where you have a company that has expressed some wish and has taken some steps towards getting ready to come to market, then you would really have to prove that the barriers to entry are insurmountable before you would say that they're not a potential competitor. And that, I think, is something that is of much broader potential relevance, and I think Pat's going to comment on that.
Thank you, Sophie. I mean, it's interesting. These cases, I think, have broadly been seen, at least when they began, as being of particular interest to the pharmaceutical sector and perhaps only to small parts of that sector. I do think, however, as the Commission has developed its theories of harm and has had the perhaps unfortunate experience of finding the facts colliding with its preferred view of the world, it has had to shift the way in which it looks at some pretty critical aspects of competition law to try and ensure that it was able to reach the conclusion that it thought was appropriate in all the circumstances. And I think the issue that Sophie's just been talking about is the way in which the Commission approaches the concept of potential competition is really important. It's important both in very specific circumstances, like the application of some of the block exemptions, but it's also very important in the context of competition policy more generally, where the Article 101 guidelines and quite a lot of the case law tells us that the application of competition law has to look at the impact on competition in a realistic way in the legal and economic context. And there is a sense, and perhaps I'm speaking out of turn here, but I think there is a sense among a number of competition lawyers that the way in which the Commission has shifted the goalposts for looking at potential competition is really beginning to step over those lines a little bit. Now, looking at one area where that might be of particular relevance to people in listening to this webinar, in the context of licensing, you will all know that both under the research and development block exemption, but more particularly under the technology transfer block exemption, there is a very distinctive difference of approach in relation to agreements entered into between competitors and between non-competitors. And that is pretty critical in normal commercial life. And the guidelines and the way in which this has been approached in the past say, of course, that a blocking position can mean that the parties are not potential competitors. So if there's a genuine blocking position, for example, the existence of a patent, that might give rise to an assumption or presumption that the parties are not actual or potential competitors. Now, the way in which the guidelines now approach this question, following the Commission's investigations into Servier and Lundbeck, is to say that where the parties have a common interest in being qualified as non-competitors, then the Commission may require particularly convincing evidence of a blocking position. And of course, if you remember what I just said, which is that the tech transfer block exemption in particular treats non-competitors significantly more favourably than competitors, you can see that there would in most technology transfer agreements be a common interest in claiming that the parties are not competitors. So that means, I think, that whereas in the past it would have been possible to just look at the patent portfolio of the two parties and work out whether they had patents that at least in principle appeared to be valid and appeared to read on to the technology or the therapeutic field in which the license was being granted, that was likely to be sufficient to give you some comfort that the parties were not actual or potential competitors. That unfortunately no longer seems to be the case, and it's quite clear that you'll have to look a bit more closely. And just having the opinion of an in-house expert will no longer be sufficient. You'll have to look at the entire market context. You need to look at the areas where the parties do compete. You have to look at their pipelines. You have to look at whether or not they do have disputes in a related area. You may want to look at whether the licensee has ever tried to enter or thought about entering. And one of the questions that will be critical, I think, and this does go back to the J&J Novartis case, is the extent to which the licensee will genuinely work the licensed invention. So if it doesn't appear that there's going to be significant effort to develop and commercialise the invention, then that may give rise to real problems in the context of whether or not the parties are potential competitors. So that's just one implication. I think another implication is that the new technology transfer block exemption and the new guidelines take a much stricter approach to non-challenge provisions than perhaps they did in the past. It used to be the case that a provision permitting the licensor to terminate the license in the event that the licensee challenged the patents was regarded as being broadly acceptable. That's no longer the case. Such provisions now are excluded from the coverage of the technology transfer block exemption, except in fairly limited circumstances. The first is which there is an exclusive license, so that the licensor is really tied very closely to the success on the market of the licensee. In those circumstances, a right to terminate on challenge may be acceptable. And otherwise, where the challenge is only really to things like ownership rather than the fundamental validity of the intellectual property right in question. So the way in which the case law has developed has really given rise to some significant changes. One thing that perhaps people haven't thought about so much is the way in which the Commission has looked at the overall relationship between parties. So a very broad approach to linked transactions. It's always sensible, because of the way competition law looks at the impact on reality as opposed to legal constructs, to have regard to the overall relationship between parties when you're thinking about the competitive situation in which they find themselves. Following the Servier case in particular, I think it's very important to bear in mind everything that's happening in a commercial relationship, the contemporaneous evidence that's being created on your files, and that may even mean that you have to be careful about the way in which the drafts of the agreement are being developed over time. Because even though the final agreement may not contain particular provisions that might have been in the agreement earlier, that can be taken as being an indication of the way in which the parties were approaching a particular transaction. One development that isn't particularly related to the line of cases we've been talking about today, but I'll just throw in as a bit of a freebie, is the question of the enforcement of royalty obligations once a licensed patent has been invalidated. Now, this is a case at the Court of Justice which is pending following a reference, I think, from the French courts, and it relates to an agreement between Genentech and Herbst. Now, the technology transfer guidelines tell us pretty clearly that post-expiry royalties, generally speaking, are legitimate in the context of EU law, perhaps a little differently from the US, where there's been a recent Supreme Court case, I think, which upheld the general view of US law that post-expiry patent royalties were not acceptable. We'll have to wait and see what the Court of Justice does in the Genentech and Herbst case, but it's definitely one to keep an eye on if you have got license agreements out there that provide for the continuing payments of royalties after expiry of the technology. For example, because the license was granted early, but the patent didn't start to be commercially valuably worked until quite late in the life. So those are situations which can give rise to that sort of commercial reality, and we'll have to wait and see what the Genentech case brings to us. Now, one other issue that we want to touch on briefly before we finish with the wider context, I think, is the question of dominance. And I think Sophie is going to speak briefly about how that is affected by recent events.
Yes, so I think apart from the patent settlement aspect, the pure patent settlement aspect of it, the Servier case is a bit of a wake-up call for the industry. Servier's drug, perindopril, is a type of hypertension treatment known as an ACE inhibitor, which is one group of type of hypertension treatments. There are a number of other types. The most up-to-date one are the ARBs, the angiotensin receptor blockers, and there are a number of older classes of drugs. Now, what you've got on the picture there is a list of all the drugs within this class of ACE inhibitors. So there are 16 altogether. I mean, that's perhaps a bit misleading because there are probably only a handful which were actively marketed, and there's probably also a split between those which were the more modern form of ACE inhibitors compared to some old ones. But nevertheless, the traditional approach of the Commission in looking at markets has been, in the pharmaceutical sector, has been to look at the ATC index and to find they start off at level 3 and then they might move down to level 4. But what you've got on the slide is level 4. So at level 4 there are 16 different drugs, of which perindopril is only the third largest selling in some countries. In some countries it's not sold at all. But nevertheless, the Commission has reached a decision that has held that perindopril alone is the relevant market. So as soon as, in such circumstances, because Servier at the time of the event still held patent protection and there was no generic entry, at least in the UK, for example, it follows tritely that Servier has a dominant position in that market. So the Commission looked very much at price impacts, and it said that the only time you get price competition, which really isn't exactly price competition, it's more just a shift of volume from the originator to the lower price generics, but anyway, the only time that occurs is when you get generic entry. And Servier felt that it competed with other of the ACE inhibitors at least, such as Ramipril, which is the biggest selling, but because when Ramipril became generic there was no significant effect on the sales volumes for Payfordelay, the Commission said, well, Payfordelay is clearly in its own market, and therefore a dominant position follows. I think there's probably a couple of other things that are worth noting. The fact that Payfordelay is a hypertension drug, it means that it tends to be prescribed on a long-term basis. With drugs that are prescribed to patients, there's always an issue of stabilisation, and it may not be that easy to switch from one type of drug to another. In some ways, it's a kind of experience good, in the sense that once a patient's stabilised on the drug and they're responding to it, then the experience shows that that drug works for them. But I think this narrow approach, because of those factors, I think this narrow approach is potentially applicable at least to any sort of maintenance medicines which have to be taken over a long period of time. But given the emphasis on econometric analysis of purely based on price competition, which as we all know is not that relevant in the pharmaceutical sector in the way it is in other sectors, but because of that, I think there must be risks in other pharmaceutical markets as well for a very narrow market to be identified. And the obvious consequence of that is that once you've got a very narrow market, you also have far more companies that are potentially dominant. And then all the sorts of things that companies, at least originator companies, wish to do to try and mitigate the effect of generic entry are potentially going to be problematic. There's been a lot of discussion about AstraZeneca over the last few years, but it's worth just jumping back to look at its description of competition on the merits. Because once you're in a dominant position, that is what you have to do. You have to compete on the merits. And in AstraZeneca, there was a concession that pure late life cycle management strategies, which have been designed to minimise generic sales erosion, may be legitimate and they're part of the normal competitive process. But I think the but's quite a big one. It's not that easy necessarily to distinguish between what's competition on the merits and competition which may foreclose. There is a discussion about this in Servier. If for those who are interested, it's paragraph 2766. And at that point, the Commission says, for those who are still awake, that a strategy of this kind is generally legitimate. So that's a strategy to delay generic entry. A strategy to delay generic entry is generally legitimate, and apologies to the generics for that, to the extent that it resorts to measures representing competition on the merits, being competition on product quality, strength of the patented technologies, and similar. But the use of a narrower strategy to use measures which may deviate from competition on the merits and are capable of producing foreclosure effects may infringe, even if the goals achieved could have been achieved by legitimate ends. And there I think we're a bit back to the Lundbeck refrain of the means used matter. And perhaps, given that we're getting towards the end of the time here, I'll jump to some of the conduct that has been held to be an abuse of a dominant position. Servier again gives us some new points. For one thing, the patent settlement agreements themselves are held to be an abuse of a dominant position as well as an infringement under Article 101. The way the Commission looks at it is not to pick out each individual patent settlement as an abuse. Rather, it says, Servier, you entered into 5 or so patent settlement agreements over a 5-year period, and you also purchased an allegedly competing technology. And that, all taken all together, represents a single continuous infringement of the competition rules, which of course allows the fine to be levied for the conduct throughout the whole duration of the period. Some other types of conduct that have been sanctioned, product hopping or switching. So when you're trying to shift consumer demand off a product that is about to run out of patent protection onto a new patent protected formulation or whatever. That's been punished both in the UK in the Reckitt-Benckiser case and more recently in the US in the Namenda case. Actually, I think it's fair to say that's a kind of interim finding at the moment, but one that supported a mandatory injunction against Actavis, which was the manufacturer of Namenda. Pat's mentioned the denigration cases. They're again forms of abuse case and rely on this kind of narrow market definition. Patent clusters is an interesting one. It's mentioned in Servier, although Servier is not strictly speaking punished for it. Another case where the Commission hasn't managed to find an infringement, but where nevertheless the issue was a live issue, was a few years ago in an investigation into Boehringer Ingelheim, where I understand that Boehringer was alleged to have patented around a competitor's product in order to prevent them from perhaps launching follow-on products. And that there was perhaps enough in that allegation for Boehringer to withdraw some of the applications, so a sort of behavioural type remedy, even though there was no infringement finding. And Pat's mentioned the other cases, but I think the take-home point is really that it's tempting to think that as a business person working in a pharmaceutical company that your product competes with other like products, perhaps of the same class, perhaps of a different class. But when you're looking at your late life cycle strategies, I would really urge you to consider that a narrower market definition may apply, and to be perhaps more cautious than you have been in the past. Which is not to say that you can't do anything, but caution is nevertheless to be a watchword, I think. And just to finish off, I thought, given what Sophie's just said, it's worth keeping an eye on what's happening outside the pharmaceutical sector, because it does have real implications for the pharma sector, particularly given what's been happening in that particular context. And the last slide did mention private litigation. We talked a little bit about chemistry. There is an increased emphasis on private litigation across the competition world in Europe. The European Union has passed the Damages Directive. It's clear now that there's the possibility of mandatory orders and injunctive relief. Here in the UK, the Consumer Rights Bill, Consumer Rights Act, is going to come into force on the 1st of October. And one of the consequences of that will be it will be considerably easier than it has been in the past for class actions, loosely called, to occur in relation to competition litigation. The Competition Appeals Tribunal will be given additional powers. It will be easier for small and medium-sized enterprises to bring competition claims, and the consequences for them of doing so may be less. The ability to seek injunctive relief in relation to competition issues before the CAT will be easier than under the usual High Court regime. All things that I think are a considerable threat to companies which are so much in the competition spotlight as companies in the pharmaceutical sector. So that's a broader competition law issue that I would, again, like Sophie, urge you to think about and perhaps to look at as part of your overall compliance strategy. Other things that are going on, perhaps less directly relevant to the competition, to the pharmaceutical sector. I've mentioned earlier the CMA's paper on rebates, and on the slide I've given reference to a couple of recent European cases on rebates. Both Intel and Post Denmark 2 are worth looking at if you do have rebate or discount arrangements in your distribution arrangements. Pricing parity obligations are a form of commercial provision that have really taken the spotlight in the TMT sector, particularly online supply of products. In the pharma sector, perhaps similar principles might be thought to apply to things like equalisation deals. It's worth thinking about. And finally, although the Commission's e-commerce sector inquiry, sort of like a big brother to the pharmaceutical sector inquiry, is not of direct relevance to the pharmaceutical sector. I think what it does show is that the Commission is perhaps, having not looked so much at parallel trade in recent years, is really now gearing up to focus very, very directly on the completion of the single market, not just for physical goods, but now also for intangible products.
that might have a knock-on effect in the pharmaceutical sector. This last slide has been much less about bright lines and more about crystal ball gazing, but nevertheless I thought it was useful just to give you a little bit of a broader perspective on the reason why competition law should be, I'm afraid, finding its way up the agenda. And I think we've more than spent our time with you today. If this is an area that's of interest to you, I commend you to our blog on our website, the clipboard, which looks at issues to do with the interrelationship between competition law and technology in the broadest possible sense. Other than that, please do log in again for further webinars, and we hope that you find today's presentation helpful. Thank you very much indeed.